Hi, I'm Kay. My question is for Attorney Sonia. So for clearances and finally, so the advisory was just recently issued. So what if the employers currently have ex-employees who have not yet gotten their final pay for one reason or another? For example, they are award employees or failed to complete the clearances. Some of them might have still have the company properties or some accountabilities. Some might not already have accountabilities but did not go the usual clearance process. That's why the final pay is still with the employer. So what is the best way to deal with this given the Dolly advisory? So are we now required, if we wanted to comply with advisory, are we now required to release it and contact these employees? And what, since the advisory does not have any transitionary period, what would be the advisable period to be able to find them or release them if we really have?
Thank you for that question. I think it will not be able to comply with the 30-day deadline if the employee has been dismissed way before the issuance of the advisory or resigned way before. But my recommendation is still within the 30-day period from the issuance of the advisory, issue a letter to our former employees, again reminding them that their final pay is already available, subject to compliance with clearance procedures and return of any accountabilities or company properties. At least we'll be able to document. I think the important thing here is to document by way of a letter which we send to the employees by courier or registered mail, or ideally by personal service with asking them to acknowledge receipt. So that later on, if for instance the employees decide to file the complaint for unlawful withholding of wages, we can show that we are actually ready and willing to release their final pay. But we just wanted them to comply, pursuant to the case of Milan, to comply with clearance procedures. Now, if we're able to establish that there's no accountability really, or there's no unpaid debts by the employee, maybe we can also tell the employees that they can just pick up their final pay anytime. That's one solution. Or I've seen some clients, they really want to pay they have a lot of unpaid final pay because for one reason or another they cannot locate the employees. Maybe one practical solution is if the employees have payroll accounts open by the employer, and the employer is aware of the accounts, not to cause the closure of the accounts yet. So that if there are no accountabilities, it would be easier for the employer to just deposit the final pay to the payroll accounts of the employees.
Another question. So,
Before we proceed, gusto ko dito pag kami Q&A, pag may taga-dole, pwedeng ipasa agad natin sa kanila yung tanong, di ba? Ma'am, baka po may inputs kayo doon sa question ni ma'am.
Siguro po with the labor advisory, hindi po sa office namin nanggaling yung issuance. So it is with the PLR. So siguro po adjust ina-note na lang namin yung concern and we can provide some answers or input dun po sa question. Kasi baka mamali yung sagot ko, sir.
Okay, thank you.
So, attorney, a while ago you discussed the Milan case. So, you differentiated, you defined the wages and then the difference with the final pay that was issued by the Dolly advisory. And you mentioned that the Dolly advisory final pay includes separation pay. It's not really the wages defined by 116 on employers being allowed to withhold. So now, given the Milan case and the advisory, if really we did not release the final pay in full because of certain accountabilities that may be more than the amount, even including the separation pay. And since the 116 only pertains to wages, if we really wanted to comply under the law on not withholding unreasonably, can we just withhold the separation pay because it's not part of the wages of 116? and then just release the portion that pertains to wages and not the separation pay.
Well, if you would want to withhold, I don't think the basis will be trying to make a distinction between separation pay and wages. It's better to just cite Milan because ultimately, if we say wages, separation pay anyway is for services rendered. It's recognition of the tenure of the employee for long years of service. Although, of course, there are Supreme Court decisions which state what is the rationale for the payment of the employee's separation pay. Pursuant to Supreme Court decision, separation pay for authorized cause is actually, quote-unquote, yung ginagamit ng Supreme Court, wherewithal, which is to try to tide the employee over while he or she is looking for another job because he or she was dismissed due to authorized cause. So, in that respect, we can argue that separation pay is actually not compensation for services rendered because, as noted by the Supreme Court, it has a different purpose. But nevertheless, I think an argument can also be made that we're giving separation pay because of the tenure. So indirectly or ultimately, it's also for services rendered and could also be considered as wage under Article 97F of the Labor Code. So again, the justification is not really the distinction between separation pay and wages. I think that is the justification still is that there are accountabilities which are much more than the entitlement of the employee.
Most of employers does not also have quit claims aside from the clearance process. So that's the end of the clearance process before employers release the final pay. So in the Milan case, there were two items that the employer wants the employee to do: return the properties, and then there's a MOA saying that you are releasing the employer. The decision of the Supreme Court is that you can withhold the pay because there's a company property. So that's the gist of the decision. But it's not really
mentioned
clear.
that.
Yes,
Good
on the
question.
MOA.
It's actually a usual concern or requirement. Can we say that actually the signing of the quit claim is part of the clearance process, such that we can withhold pending the execution of the quit claim? I don't think so, because I think the justification of the Supreme Court is unjust enrichment. So the employers given the opportunity to withhold because there are accountabilities of the employee, and the employee is not really accountable to the employer or has an obligation to execute a quit claim. So we cannot make as a condition for the release of a final pay or separation pay the execution of a quit claim, releasing the employer from liability. What we can do is to require, as a condition for the release of these accountabilities, the execution of a simple receipt or acknowledgement, but not a release.
Last na lang.
So,
Last na talaga. Certificate of employment. So the advisory just mentioned that you need to release it within 3 days from the request. So for ex-employees, there's no mention that the employers, need to release it at the time that they separated. Does that mean for ex-employees, they need to request first before we actually release it?
Because I think so. It's what's well, at least that is the straightforward interpretation of the provision. There's no obligation to automatically issue a certificate of employment.
Good afternoon. My name is Richard. I'm a senior associate in Cognizant Technology Solutions. And then for the in reference to her earlier questions about quit claim, is it mandated to notarize the quit claim?
It is not. Well, notarization makes it easier for us if there's litigation because there's already a presumption of due execution or voluntariness of the quit claim, but it's actually not a requirement for the quit claim to be binding. In fact, the labor code or the NLRC rules of procedure also state that technical rules are not binding or are not really strictly applied by the labor courts. So the rules of evidence, which normally would require notarization of documents, are not really, strictly speaking, or strictly applied in labor cases. But nevertheless, are we saying if a quit claim is notarized, then it's foolproof? Not even, because of Supreme Court decision stating that quit claims are frowned upon. And it's up to the employer to show that the quit claims were executed by the employee voluntarily, knowingly, and for valuable consideration. I think ultimately we should not just rely on quit claims. We should rely on the strength of our case. For instance, if we dismiss an employee, then we should be prepared to justify the validity of the dismissal and not just rely on a quit claim.
Okay. Another question in reference to final pay processing, and then in which the employer is mandated to deduct unliquidated amount, let's say travel advances or cash advances. Do we need to require a former associate to sign an authority to deduct form?
I think there's a dole order in 2018. If I'm not mistaken, it's 185-18. It provides for requirements in case of a deduction for unpaid debts. So it requires a written authority by the employee. While there are provisions, there's a provision in the Civil Code on offsetting or compensations, as I've said, when debts are both due and demandable and it's liquidated. But in these instances, for instance, I think the usual issues are training bonds or agreements to reimburse certain costs incurred by the employer. The employee may dispute his or her liability for these amounts because it's actually, the training, for instance, is actually for the benefit of the employer. So we should be able to establish that the cost of the training is really reasonable, and it was also for the benefit of the employee, and the employee agreed on for instance, that he or she should stay within a certain period of time after receiving the expensive training, and therefore the employer could deduct from the final pay. Or if the employee is indebted, then it's really a due or liquidated amount, and the amount is not uncertain. So in those respects, I would recommend the execution of an agreement or authority to deduct. In fact, usually when we prepare employment contracts, we already include authority to deduct unpaid obligations or liabilities. Except that, of course, even with those general provisions, we should be sure that the amount is liquidated. Hindi siya parang tinatansya lang natin kung magkano.
Okay, for my final clarification, in the cases wherein a associate will be transferred to a global assignment, for a temporary global assignment, is it mandated to the host employer to process or to the home employer to process the final pay of the associate will be going to a host employment?
I think we need to find out first what will happen to the employment relationship. When we say global assignment, is it a mere transfer or
Temporary
secondment?
transfer.
Or are we saying that the employment relationship with the original employer is not severe? Because if it's not severe, then there is no final pay to speak of. It's just a temporary secondment, as we've said. And the wages or salaries of the employee will probably still come from the original employer. I think in those instances, we need to take into account the so-called fourfold test of employment. Who's paying the salaries, who's exercising control over the employee, to find out who the real employer is. And in any case, we also need to find out if there was an agreement to terminate the employment relationship with the original employer before the secondment or global assignment. Especially, there might be implications on whether the employee will be considered as an overseas Filipino worker. If it's there might be problems already or issues with the Bureau of Immigration. You've seen clients asking employees or seconding employees to affiliated companies abroad, but when asked by the immigration officer, the employee does not know how to give the right answer, or of course it's confused. The employee is giving the impression that he's being employed by a different employer. So in such a case, the Bureau of Immigration will ask for certain additional requirements for OFWs. Or for instance, an overseas employment certificate, as opposed to a mere secondment, wherein the employee remains an employee of the Philippine entity. So general rule, if there's a termination or severance of the employment relationship, then the provisions of Advisory 6/20 will kick in. If there's no severance, the employee remains an employee of the Philippine employer, then there's no requirement to give final pay.
Sure, thank you.
Hi, attorney. Just a clarification. So the 30 days camp po will start upon completion of the clearance.
It's actually from time of termination of the employment relationship.
Okay.
Except that, of course, pursuant to Milan, we can take the position that the 30-day period will not apply unless the employee has already completed the clearance process.
Alright. Thank you, attorney. And then my second question po is, you mentioned that part of the separation pay is the conversion of SIL, whatever is remaining.
Part of the final pay is defined in the advisory.
Alright, so what if, for example, with the assumption, let's say we have an employee who has been with the company for more than a year. So technically, that person has 5 SIL. Pero let's say the company has, more than this type of leave. And let's say the employee did not use and utilize any of the leaves. Do we convert the entire amount, which is equivalent to 5 SIL?
There are no used leaves.
Yes,
Well,
kasi
at the
po-
very least, we need to convert the 5 days SIL if the employee did not take any
Right.
leave at all.
Right, kasi...
On the cash conversion of the other unused leaves, it will depend on your company policy.
Okay, so for example po, in most companies right now, I believe we would offer more than above than the required by law. So let's say a company offers 12 SL, 12 BL, and with the assumption that the employee is a workaholic, hindi nag-leave, walang work-life balance chart. Joke lang po yun doon ha, meron pong work-life balance. Pero let's say hindi po siya nag-leave. So hindi niya nagamit yung any sick leave, any VL. So does that mean the company needs to pay a converted 5 assumption SIL sa last day?
At the very least po yung 5 days, sinasabi nyo entitled yung first 5 days. Yung rest, again, depending on company policy.
Okay.
Maybe let's complicate the matter a bit. Paano kung merong 10 days na VL, 10 days SL,
Yes.
tapos nag-VL yung employee ng 6 days, tapos saka siya nag-resign? Are we required to pay 5 days SIL? No, we're not. If we're saying that our VL and SLs are equivalent to the SIL already. So if the employees have already taken 6 days of VL, then effectively nauna na yung SIL. Pero mas maganda, i-clarify natin sa policy.
Okay. Thank you po.
Di lang po ako yung speaker, ah.
Sir, good afternoon po.
Baka si Miss Jen, si
Ayun,
Maria.
sir, good afternoon po. I would like to ask for your opinion lang po. Kasi we have particularly sa employee namin na may nag-immediately resign and sometimes nag-aawol without notice of resignation and without tendering 30 days notice. So are they qualified for the cert clearance and COE?
Good question. Kasi may provision sa labor code kung meron requirement to give 30 days notice.
Yes, sir.
And in fact, the employer could theoretically file a complaint for damages if the employee fails to comply with the 30-day notice period. But the question is the right of the employer to damages, is the damages here liquidated or due and demandable?
Yes, sir.
So kung wala naman pong liquidated damages clause sa employment contract, my opinion is that it's not a liquidated or due and demandable claim as to allow the employer to withhold from the employee's final pay just because the employee failed to comply with the notice period.
So even they self-declared a wall?
Or declared a wall. If
Yes,
we are
sir.
talking, because we're talking about accrued salaries and benefits,
Yes, sir.
naipon na ng employee dyan. Yan.
Yes.
Ang claim ng employer, dahil nag-awol yung employee or hindi nagbigay ng notice, parang nag-suffer ng damages yung employer. Di ba?
Yes, sir.
Kasi
So-
hindi nakapag-prepare, pero iba po yun, doon sa yung right of the employer to possible damages versus the accrued salaries and benefits of the employee, which is what is really envisioned under Advisory 6/20. So pinag-ipunan ng employee yun, kinita niya na yun, sa kanya na yun, hindi natin pwedeng i-withhold dahil meron tayong hypothetical claim for damages unless our claim is due, demandable, and liquidated.
Okay, sir.
So of course, we need to differentiate between our cause of action for damages and the employee's accountabilities as described in Milan. Yung mga sure tayo na company properties and returned equipment which is really belongs to the employer. So yun, pwede natin i-withhold. But not really yung theoretical claim for damages.
So we considered legal yung immediate resignation?
If you're asking if the employee will immediately resign,
Yes, sir.
I would think so because we have provisions in our Philippine Constitution against involuntary servitude.
Yes.
So we cannot really say the employee, hindi ka ba ng 30 days, bukas kakalat ka namin sa office namin, trabaho ka din ng 30 days. Hindi po pwede yun. Ang pwede gawin ng employer, hindi ka nagbigay ng 30 days notice, we can actually file a complaint for damages against you.
Even without contract, sir.
Even without contract because we can invoke the provision of the labor code.
Sir, we have last one question, sir. We have a resigned employee. Actually, yung clearance niya was already forwarded to us. Unfortunately, one department head didn't sign. Parang mayroon siyang issue from yung may case sila, but unfortunately, we already received the resignation. Until now, hindi pa pinipirmahan ng department head yung clearance. Are we liable for that?
I think we need to look into the reason. If the reason for not signing the clearance is that the employee has unreturned accountabilities, as described in Milan, then maybe we can say that the employee has not completed the clearance process. But if there's a different reason for not signing, I'm not sure kung hindi nagpaalam ng maayos yung employee.
Sir, nag-file naman siya ng resignation and tinanggap naman po ng department head yung kanyang
Ano po kaya yung reason, ma'am, for not signing?
Sir, mayroon po kasi siyang case. Unfortunately, parang nag-bounce check. And yung penalty siya, may penalty siya, sir. Part of it was already waived by the bank. And I don't have the clear amount ng remaining. Bali po, two of them were involved for the bouncing check. Kaya lang po, walang final hearing for the, dinatnan ko na lang kasi yung case niya.
Yun po ba yung sinasabi yung bouncing check, may utang yung empleyado, tapos babayaran niya ng cheque, tapos tumalbo?
Hindi, attorney, bali, accounts payable siya from
Different, in the performance of the work.
Yes, sir, bali,
But it's not an account. Depende po, if we can make the claim that it's an accountability of the employee, maybe we can take the position that we can withhold. But if it's not really an accountability of the employee, then I don't think we can justify the withholding of the employee's final fee.
So, no, attorney, no admin hearing was done. So, yung final amount na supposed to be due for the bouncing check na charge ng bank is part of it was already waived, as I've said earlier. But meron siyang particular amount pa na remaining na hindi clear kung i-deduct pa sa dalawang employee or not. So, yun yung...
Tingin ko po kung hindi clear na accountability ng employee, we cannot withhold. So, kailangan medyo malinaw na accountability siya ng employee.
Yes, sir. Thank you very much po.
In fact, just to add, yun nga po yung when I cited that dole order issued in 2018 for deductions. Usually naman yung deductions naman doon that was covered in that department order for deposits, for instance, by security guards. It's recognized as motivated tool for kunyari lost na naiwala ng security guard yung baril na ina-assign sa kanya. So, pwede may recognize in that industry na mag-deposit. But there are also requirements for the deduction due to damages or losses. So, among the requirements is that the employee's been afforded due process. So, kung sinasabi niyo ma'am, hindi nga malinaw na accountable yung employee dahil walang due process, baka hindi po yun yung accountability na ini-envision dun sa Milan case. By citing the Milan case, we're actually already taking somewhat an aggressive stance. So, if we're not even clear about whether the employee is accountable, it would be more difficult for us to cite the Milan case to justify withholding.
Good afternoon. My question is for Attorney Marian. Ako, okay lang. Kahit si Attorney Zuniga na lahat. Nalileft out daw po kayo. Okay lang. It's regarding the EML. Di ba, our employees, solo parents are entitled to additional 15 days leave if they are qualified under the Solo Parent Act. However, we've had instances that yung Solo Parent ID will only be released upon delivery. So, parang tapos na yung leave niya, hindi pa siya nag-issue ng Solo Parent ID. Do we still give her the 120 days leave or just after na lang po yung adjustment?
Nako, hindi ko alam kung paano natin gagawin yan. Kasi requirement na dapat qualified siya as a solo parent under the Solo Parent Act. So, kung hindi pa, I think you would have to ask DOLE kung paano nila i-implement yan kapag hindi pa na-issue. yung ID niya.
Yes, and there's another case also that she already has a solo parent ID, but it's for her two existing dependents. For the unborn child, hindi siya included, syempre, dun sa solo parent ID. But the mandate, we clarified with SSS, pero ang advice nila sa amin, we should give the 120 days leave dahil may solo parent ID siya. Even though hindi pa kasama doon yung third child niya and it's with another partner.
Possibly, tama naman yun. Kasi because under the law, nakasulat na naman qualified siya as a solo parent. Eh. Hindi naman sinabi na dapat kung yung unborn child niya, ilalagay na niya as dependent niya sa solo parent. Eh. Kasi to begin with, solo parent na siya. So she should be entitled to her 120 days because she is a solo parent.
I have another question, but I think it's more on separation of.
Sige.
Regarding sa ano din po, actually it's related also
Dahil po,
to.
last question, and then may comment here si Attorney Liz.
Kasi I think you should also qualify dun sa solo parent yung importance ng ID. Kasi parang sinabi mo kanina, na-issue na siya ng ID eh. But you have to bear in mind na yung solo parent ID mo, annual yan. Di ba? Nire-renew yan eh. So, kailangan i-stress mo rin na dun sa kung sino man yung empleyado nyo, i-check mo kung meron kang valid solo parent ID. Ayan. Yun lang yung gusto ko kasi may iba tapos na eh.
Pero ako personally, parang it's a matter of complying with an administrative deadline. If you know that the person is a solo parent, so just comply na lang natin sila, and in the meantime, at least take the position that she's entitled to additional benefits.
Regarding din po sa, kasi we have yung maternity, di ba, it's advanced by the employer. And then, at sometimes there's a delay and hindi siya nabibigay agad ni SSS. So, yung ibang employers, they withhold a portion that is for payment pa ni SSS. Kapag hindi pa siya, hindi pa comply yung employee sa requirements niya, is that okay po? Na i-withhold muna yung final pay niya kasi meron pa siyang unpaid from SSS kasi kulang siya ng requirements.
Yung accountability niya po sa SSS.
Yes, pero we advance, the company advance the amount.
But you're required to advance the amount.
Yes.
But what you're saying is that the employee has not
Comply with the requirements,
With the
so we can
requirements.
secure payment from SSS.
So we are not reimbursed by SSS yet.
okay. I think you can take that position because it's an accountability of the employee to you. But of course, there's the Department of Labor here. Maybe you can get some level of comfort. Ma'am, baka meron kayong comment. Sa BWC na yata yun.
Opo, pero we're not part in the drafting of the EML na guidelines din po. So, we're taking notes po yung mga concerns ninyo. So, dapat pala yung isang division namin may representative din dito. So, sila po kasi yung in charge with the EML and telecommuting at the same time po yung nire-discuss din ni Sir. So, from other bureau naman po yun. So, sige po, i-raise ko yung concerns na nag-gather namin on the EML. And maybe we can coordinate with PMAP para we can give answers din po.
Question for separation, sir. Separation.
Basta separation sa
Dito po ako sa
Good afternoon, attorney. My question is, are we allowed to release PCOE even the clearance is still on process?
It's a separate issue now, yung issuance of the certificate of employment. So if the employee requests for the COE, so we cannot invoke as condition for the release the completion of the clearance process.
Can we, because we have a provision, I'm sorry, we have a provision on our COE at the very bottom. It says that the employees
Already clear from any accountability. So if the clearance is still in process, so are we supposed to remove that portion of the
And
clearance?
I think what we can do just to comply with the provision of the advisory is to remove that clearance. Just state that the employee has been employed from this date to this date and occupying this position.
Okay, thank you.
afternoon. So, just more of clarification about the time process. So, you mentioned earlier that if an employee has some items that need to be returned to the employer, are we required to compel them to process the clearance?
If there are unreturned company properties, you mean?
Yeah, like for example, especially us that we are working in a BPO
Okay.
industry, so
Yes,
all of the employees actually have items to be used like the headset,
Okay.
the proximity card. So right now, we have about thousands of employees who have not processed the clearance yet.
Okay.
So meaning we're expecting lots of expenses if ever we release that without them
Without
returning.
requiring the return. So
Exactly,
you can
yeah.
require the return of the company property as part of the clearance process. In fact, it would be ideal, I think,
Yeah,
well, you can just state they should comply with the clearance process, and then your clearance policy would already state that they should return company properties. But for additional protection, maybe you can write to employees and specify the unreturned company properties, like headsets.
Yeah, but our big problem right now is for those employees who got separated long time ago, like years ago.
Okay.
So they have not processed the clearance, so it means they have not returned the items yet. So are we required to chase them?
Okay. Yeah, I think it's just a matter of documenting to be able to invoke the Milan case that there are unreturned properties. So for instance, if the employees resigned or were dismissed less than 3 years ago, my recommendation is that to protect yourselves, issue the based on their last known addresses, issue letters stating that their final pay is still with you, and they should comply with the clearance process for the release of their final pay. Now, for those who have been dismissed for more than 3 years, then you can take the position that their claims are already prescribed, because under the labor code, money claims prescribed within 3 years. So at least there's a limitation on your.
Alright, thank you for clarifying. Sorry, just a follow-up question. So, if ever, okay, so moving forward, in case we are, well actually, we need to be compliant with the 30-day period, right? From the time the employment got terminated or separated. So, the 30 days actually is kind of, what do you call this, parang anesthesia for some, like for us, that our payroll team actually, or our payroll is being processed by month. So
I can
every
understand
season.
for companies who are employing thousands of employees, even without any issue on the clearance or unreturned company properties, 30 days might be too short. So maybe it's up to the for consideration of the Department of Labor. Maybe they can look into this further and consider other exceptions or extending the period.
And sorry, last question. So are we talking about business days or calendar days?
It's calendar days.
Alright, thank you.
Any more questions?
Kapihan to, ba't walang kape?
I have a question.
May kape po doon sa kabilang room.
I have a question. Can we invoke Milan case regarding unserved term for the training expenses employees sent abroad?
I think what we need to establish first is that there's a valid training agreement.
Yes, there is.
So kung may valid training agreement, valid yung cost, reasonable valid yung duration ng training bond, so it's a demandable or obligation or an accountability of the employee. So we can invoke the Milan case.
Copy. To Attorney Marian, I will speak on your behalf. Very common kasi ito eh. Employees who would want to return to work even if not yet completing the 105 days kasi naiinip na sa bahay, gusto na magtrabaho, but the 105 days is already paid, di ba? What if the employee willing to work without pay? Willing to work without being paid, just gusto niya lang magtrabaho.
Then I guess sorte yung employer niya.
Naiinip lang sa bahay.
Yeah.
They can.
There's no prohibition if they want to go to work.
Provided they have a fit to work.
It's not actually required under
It's not.
the EML.
Okay.
Pero huwag naman po kakapanganak lang kahapon, papasok.
Kasi I remember even during the 78 days, the 60 days, some employees would want to come back to work. Lalo pa ngayon 105 days. Di ba? Yes, yes.
What if something happened to that employee? Is the employer accountable?
I was about to say yun yung medyo...
Yeah, that's the risk.
If it's a work-related injury, then that would be outside the coverage of the EML already. So that would fall under work-related injuries na or disabilities. Pero if it's because the employee was pregnant, then I guess that should be her, ano na niya yun? Kasi, oo. Kasi siya yung pumasok ng, hindi naman siya nire-require ni employer pumasok. If something happens to her because she shouldn't have gone to work, then, yeah, nasa sa kanya na yun.
Well, sabi ni Sir Bong kanina, di ba, meron ng fit to work certificate. Baka at the very least, we should require that just to show that we exercise prudence. And also, of course, we need to ensure that we provided a safe working environment for the employee.
Sir, we actually inquired this on one of our DOLE sessions in Nuvali. And the DOLE personnel mentioned that it would be still prudent, as you mentioned, not to allow the employee to go back to work because at the end of the and ask for a fit to work clearance from the employee because at the end of the day, it will serve the employer better than the employee. So might as well not allow the employee to go back to work. That's their advisory then. So I'm not so sure if it has changed.
I think you need to weigh the advantages of allowing the employee to work. Because, yeah, as mentioned by Ma'am, for the benefit of the employer. So you're taking advantage of the employee's work. But if you don't want to assume the risks, then just not allow the employee to report to work.
Okay, with that, there's another
question.
Last question. We will accommodate the last question.
This is just a clarification regarding the allowing the employee to come back to work after or not completing the paternity leave. So if we allow, there are cases that we pay for the differential, right?
Yes.
For the salary. Wouldn't that be a double compensation, or how would that be treated?
No, actually, because so you pay for the salary differential. This means the difference between the employee's monthly salary and that one given by the SSS.
Yes,
So it's as if the employee is being paid for the entire month that she is not working. So if she goes to work, then she already received her salary. So you don't give an additional salary.
So no more
Because it's
compensation because we advance it.
It's like she's waiving her leave, her maternity leave. That's what the employee is doing.
Okay, thank you so much.
Okay, with that, last question.
Attorney Zuniga, we'd like to clear lang po. Yung clearance po ba, kasi yung company ko kasi is practicing releasing of clearance after 7 days of receiving the resignation. So, are we practice yung right or yung kailangan after, diba, last day ko sir today, am I able to get a clearance agad-agad? Or, kasi ang ano po nila is practicing after 7 days para makakakuha ng clearance form. Kasi for 30 days, sir, bali medyo short na kami for that.
So you just need to make a distinction nga po yung kanina, no? You're not required to give a clearance within a certain period of time. It's your right. Of course, they're subject to an agreement or company policy. What you're required to issue is the certificate of employment.
Okay.
So, pwede ilagay niyo lang doon sa certificate nga yung employment history, start date, end date, position, and not clear the employee. So, isi-separate niyo po yung document.
Okay, so we can release after 7 days.
You can release after 7 days, as long as you issue the certificate of employment within 3 days from the employee's request.
Okay, thank you, attorney.